Good morning, good afternoon, and good evening, wherever you are in the world. My name is Jasmine, SIAC's Manager Legal Strategy and Development, and I am pleased to be your MC for today's SIAC's Philippines webinar titled The Future of Energy Arbitration and the Challenges Moving Forward. Our panelists today are Ms. Patricia Ann T. Prodigaladat, Senior Partner, Accra Law, Mr. Paras Lalwani, Director, Drew & Napier LLC, Ms. Elodie Dulac, Partner, King & Spalding Singapore LLP, Mr. D. Los Angeles, Dino Ricardo T. Partner, Romulo Mabata, Buenaventura SIAC, and D. Los Angeles. Moderating this session is Mr. J.R. Robert Wheel, Member, YSIAC Committee, Adjunct Professor D. La Salle University, Far Eastern University. I will now pass the time to Rob. Rob, over to you.
All right. Good afternoon, everybody. So I hope everyone's having a fantastic day. So usually in our webinars, we start with something a bit more personal, something that is a way to get to know our panel members better. So I wanted to ask, we can do this via alphabetical order. I wanted to ask Dino, what's one of your favorite stories that made you fall in love with arbitration? Tell us your story.
There's no one particular story for me. What I can say is that I developed a keen interest in arbitration during my days in law school. When I was looking for a thesis topic, I asked around for recommendations. At that time, my father was an advocate for alternative modes of dispute resolution, particularly mediation and arbitration. He suggested that I explore issues on arbitration in the Philippine setting. Eventually, my thesis ended up being on the subject of arbitration. Since then, after much research and after having experienced firsthand some of the advantages of arbitration, like for instance, having specialized arbitrators and having less technical rules, I knew that I wanted my practice to revolve around arbitration. So that's really how my love for arbitration began.
Okay, thank you so much for that. And it's really fascinating that you've started really thinking about arbitration even during law school. Hi, Faris. Good afternoon.
Hi, Rob. Good afternoon. So the question was, what made you fall in love with arbitration?
Yeah.
I'll start off by saying love is a very strong word, but I'd just like to share how I came to be interested in arbitration. It's quite a silly story. I never took arbitration courses in law school, and I started my career out as a litigator. And I recall the first arbitration matter I was put on. My boss came to me and asked me, Paras, who do you think we should recommend to client to appoint as arbitrator? And I, coming from the court background, was like, what? You can pick your judge. What's going on? And so that's what got me fascinated in arbitration. And soon after, I learned more about arbitration and came to be very interested in it. Yeah.
Okay. Thank you so much for that. So I also came from the judiciary, and definitely that's one of the things that I enjoy about arbitration. To me, the idea of what we can choose an actual expert in the field. Yeah. Thank you. What about you, Patricia? Tell us your story.
Okay. Right. Just like Paras, I don't think love is the correct word for me. And my interest in arbitration did not really come from arbitration per se. It was more of a disenchantment with litigation. Like Paras, I started out as a litigator. And, when you're young, you go on TV, you see all these court proceedings, and you don't realize, at least in the Philippines, how long it takes. And I was so disappointed that in one case that I was handling, pro bono for a child, she was molested. It took decades for the accused to be convicted. Counterpoint is I was assigned early on to a construction arbitration matter. I was part of the team, the most junior member, and we were having hearings during holidays. And because of that, we finished quite early. Of course, there was a balancing act. It's like, do I want to have hearings and holidays? Do I want it this fast? Do I have to work this hard? That quickly? But in the scheme of things, in the end, the efficiency of arbitration, the ability to get things done very quickly, confidentially, and with an expert, I think it outweighed everything that I saw in litigation. And because of that, I became very passionate about it. And it's a good thing one of the stalwarts of ACRA law is a foremost pioneer also of ADR and arbitration. So I was under his wing and he brought me along wherever he went. And it's a good thing that I ended up here enjoying arbitration, and I'm now an arbitrator.
Thank you for that. I suddenly remembered when me and my colleagues were thinking of drafting the arbitration agreement, we were wondering if there was a way to make Boracay as the venue of all arbitration proceedings. And you see, that's a fascinating thing about our arbitration. You can have all of those. Thank you. And Elodie now, hello.
Yeah, sorry, I had a technical
No
glitch.
problem.
So I started arbitration, pretty early. I was like a trainee in an arbitration team in Paris, a bit by chance, I must say. It was years ago and I had no idea. I was actually in one of the best arbitration teams, but I was clueless. I was just doing a traineeship before my LLM. And I wanted to work for the UN. I was coming from a postgraduate in public international law. And then first case I worked on was an investment treaty case. And it was like years ago when it was just starting, there was no database, no global arbitration review. So I found it we were basically more or less making the law because there were no cases almost out there. And so it was like digging, trying to find like from international law ideas and making it as we went. And I found it very like fascinating and I loved it. And after that, I basically did only, I finished my traineeship and then I started as a lawyer in an arbitration team. So I've been like very kind of narrow in my focus.
Yeah.
But it was, I thought it had like, and still is, it's very fascinating, the flexibility and like the creativeness you can have. I think are quite unique.
Yeah, thank you. And it seems like you also started pretty early in your career and really focusing on arbitration. So, okay, so maybe to get the ball rolling, and it's something that, goes into the topic for today's webinar, I wanted to ask Patricia, could you give us a landscape? What are the things that we need to know? What's the landscape in the Philippines?
Okay, well, in terms of energy disputes, I think the one thing that we should remember is that energy is a regulated industry, right? So we have to deal with government and we have to contend with government issuances. And I think one of the most recent ones that I think we discussed before we went into this panel was the advisory, I think, that the former Secretary of the Department of Energy laid out sometime in the last quarter of 2020, when despite all the investments put into coal power plants, he suddenly said, we're not going to allow that anymore. We're going to have a moratorium and all that. And of course, the existing investors who had those plants had a different reaction. And those who were interested in providing other sources of energy other than coal power plants were keenly interested in now availing of the new policy of the government. And alongside that moratorium, I think the Department of Energy said, okay, we're going to open it up. All for 100% foreign ownership is now allowed for geothermal projects. So that, I think, was intended to try and boost interest and investment in renewable energy, which is aligned with the government's track towards a more a cleaner form of energy and a more sustainable and, I think, resilient one.
All right, so thank you so much for that and giving us a brief background of where we are at the moment. And in relation to this evolving landscape, I was hoping to ask Paras, what do you think are the types of energy law disputes that we can expect to see given the Philippines' transition from traditional sources of energy to renewables?
Thanks, Rob. Rob, I've prepared a few slides for this question.
Oh, perfect. Thank you.
Just wondering if you're able to see it.
Yes, we can see it now.
Okay.
Oh, thank you.
Thank you. All right. So to answer your question, in a sense, disputes involving renewable energy projects would fall under the same broad umbrella categories as disputes involving traditional energy projects. And that's primarily because there are a number of important similarities between both sets of projects. Both tend to be complex, long-term, capital-intensive, and involve multiple stakeholders. So those are the similarities. But that being said, there are a number of very important differences with renewable energy projects, which tend to affect the types of disputes that we will see within those categories. First, renewable energy projects tend to be constructed in remote locations or greenfield sites, which brings with it its own sets of regulatory and logistical challenges. And I'll come to this later on in my presentation. Second, you're dealing with new and often unpredictable technology with renewable energy. And that, again, because of the unpredictability of it, does lead to some disputes. Third, and quite importantly, you've got new and inexperienced entrants without a proven track record. Renewable energy is a very attractive area for people to get into. You know, it's in fashion, it's in favor both politically and publicly, and a lot of projects are flagship or first of its kind. So everyone's clamoring towards renewable energy. But that also means that a lot of entrants who enter don't really have a full understanding of the technology or the industry. And just to give you an idea of the kinds of issues this might lead to, I recently acted for a company which engaged an inexperienced solar panel solutions provider. And the contractor asked my client for a 50% deposit upfront without even taking measurements of my client's roof. And the contract, which the contractor said, you know, was standard in the industry, also omitted basic terms such as the brand of the solar panels or the number of solar panels to be provided, or even the port from which these panels will be delivered. So you can see these are the kinds of challenges that you're dealing with new entrants and what is a new and still largely unregulated environment. Finally, the procurement for renewable energy projects is not usually on a lump sum or turnkey basis, because very few suppliers or contractors have the size, the specialization, or the risk appetite to take on such a large project on an EPC or turnkey basis. So in the end, we usually see an owner enter into a number of contracts with various specialist contractors and suppliers. And this, again, has an impact on the types of disputes that you will see in the construction space, and I'll come to that. So with that being said, you know, these are some of the disputes that you're likely to see. And the disputes will arise both at the upstream and downstream stage of the project. Given the time constraints today, I'll focus on the first three of these disputes, but I'm happy to answer any questions you have in the Q&A segment about the other disputes. So the first type of disputes that we'll likely see are joint operating agreement or JV disputes. Now, due to the size and complexity of renewable energy projects, or in a lot of cases due to local requirements, it's usually undertaken by multiple parties under a joint venture or joint operating agreement. And you will at least have one local party who will be well versed in the local laws and regulations, or would be a government-owned entity. And you'll have an overseas party who brings either subject matter expertise or finances to the table, or both. And what we tend to see is that the parties' relationship usually works well at the start of the relationship. And then along the way, misunderstandings develop because there's so many players, so many cooks. And then you see a lot of disputes. So you'll see typical disputes would be, as shown on the screen, dispute over control of the JVs, allegations of breaches of contracts, deadlock situations, and standard of care issues. Now, that's one type of dispute. The second type of dispute I'll deal with is construction disputes. And this is very important because the construction stage is the most capital intensive stage of a renewable energy project, you know. So this phase tends to be the most challenging and labor intensive as well. And disputes are very, very common. Disputes can include the plain vanilla type disputes that one typically sees in construction matters, as you can see on the screen. But we are also likely to see disputes caused due to the factors unique to renewable energy projects. For example, the remoteness of the location of the project often means that there are delays in obtaining permissions, consents, or licenses from local authorities, and that leads to all sorts of delays down the chain. Parties may also face challenges in transporting large building materials to the site, or even in accessing the site in some cases. Next, having multiple small contractors is also likely to lead to a lot of challenges, like you can be embroiled in multiple claims and proceedings concurrently. There could be also higher insolvency risk because you're not talking about one big player that you're dealing with, you're talking about a number of smaller parties. So the owner or the JV takes on the insolvency risk of each of the parties. And of course, the third issue that typically arises in such situations is the knock-on impact of breach or insolvency of one contractor on the work that you've contracted to another, right? And finally, new technology, new inexperienced entrants, again, bring with it its own set of challenges. Right, now, finally, I will deal with investor-state disputes. The Philippines is a party to approximately 40 BITs, bilateral investment treaties, and it needs to ensure that it acts in accordance with those. A typical investor-state dispute relating to renewable energy, which we see with the cases for breaches of the Energy Charter against Spain in Europe, it looks like this. First, the government introduces subsidies or tariffs and assures investors either directly or indirectly that these subsidies will last throughout the course of a project. And then the investor, on the basis of these assurances and of the subsidies, invests in the project. However, midway through the project, the subsidies are removed, and as a result, the profitability of the project is adversely affected, and the investor then sues the government under the applicable BIT, depending on the wording of it, for either its breach of obligation to provide fair and equitable treatment, or in extreme cases for indirect expropriation. Spain, which I mentioned earlier, was one of the early adopters of renewable energy, and has to date faced over 50 claims for breach of the Energy Charter because it changed one of the subsidies that it gave to the early investors. And as it stands, it's been ordered to pay over 1.2 billion euros in compensation. I'm not saying this is going to happen in the Philippines, but the Philippines needs to be very, very careful that it does comply with these regulations. Because after all, we're talking about a new area which the Philippines is keen to develop right now. All right, so in conclusion, I've covered some types of disputes we're likely to see, but it's by no means exhaustive. As with every industry, we are likely to see a range of disputes in the RE space from upstream to downstream. All right, thank you.
Oh, thank you so much. Thank you so much, Paras, for really breaking it down for us. And in response, I wanted to ask Dino, what peculiarities have you encountered in your arbitration practice relating to energy disputes? Are these peculiarities specific to traditional sources of energy, or is it similar?
Jumping off from what Paras said on the complexity of energy disputes, I was involved in an energy dispute which gave rise to parallel proceedings: a commercial arbitration, an exit arbitration, an action with the Supreme Court, and another proceeding with a government agency, all pending at the same time. While parallel proceedings do occur in energy disputes, it was a unique experience for me to have 4 concurrent proceedings. My takeaway from that experience was that one should explore all available remedies in a given legal framework. A dispute may involve not only a breach of contract, but also a breach of an investment treaty or other legal obligation. In which case, apart from commercial arbitration, an arbitration based on a treaty violation or other remedies under the law may also be explored. The situation I described is not necessarily limited to disputes on traditional sources of energy. It may occur in any complex dispute, especially when investment protection treaties are invoked. I have also encountered several energy projects which involve a construction component. In the Philippines, there is a specific law which lays down the jurisdiction of the Construction Industry Arbitration Commission, or the SIAC. The Philippine Supreme Court has interpreted that law to mean that if a dispute arises from or is connected with a contract entered into by parties involved in construction in the Philippines, and that contract contains an arbitration clause, such dispute may be referred to arbitration before the SIAC, regardless of the arbitral institution specifically stipulated in the contract. Thus, even if the arbitration clause stipulates SIAC arbitration, for example, the parties may still submit their dispute to the SIAC. The law in effect automatically gives the parties an alternative forum before which they may submit their disputes. That alternative forum is the SIAC. I believe this is unique in the Philippines and is something that potential users of arbitration should factor in when their contract involves construction in the Philippines. So these are just some examples of peculiarities I have encountered in my arbitration practice.
Thank you so much for that, Dino. And in fact, I can see a few Q&As particular to the CIAC. But before we go there, I wanted to ask first, Elodie, can you share with us the typical remedies available to investors where the energy transition results in changes in laws or regulations adversely affecting their investment? Something that both Faris and Dino have alluded to in their discussions.
Yeah, but I mean, as was mentioned, like it's a new area of law, and generally in the energy sector, definitely in the renewable sector, you may have changing laws, regulations, and the trend now is for new laws to be introduced, which may affect negatively the economics of existing contracts, whether the contracts are between private parties or between an investor and a state-owned entity or the government. And the issue is who's going to bear the risk, the financial risk of that change in law. So there may be like radical changes, like Patricia mentioned, like if there is a moratorium and you had an investment and it has to basically stop, it's eviscerated by the new change in law. Then you have to look, if you have a contract with the government, as Dino mentioned, you may have a contractual avenue. Then you look at your contract, do you have a stabilization clause, and maybe a clause like precluding, freezing the law applicable to the date of the contract, in which case this new law shouldn't apply or you shouldn't bear the risk of that new law. It may be what's called an economic stabilization clause, which means the parties have to renegotiate so that the investors can have the profitability on the project, which was expected at the time it entered into the contract. And then you have to be careful how it's drafted, whether it's just making best efforts to negotiate or whether there needs to be basically an enforceable clause where if no agreement is reached, you can go to arbitration and enforce and obtain a compensation or a rebalancing of the contract. There may be less usual, but there may be things. I had a case where we used representation and warranties provisions, which the reps and warranties provided that the contract should comply at all times with the law. And when there was a change in law, then the contract wasn't complying anymore, and the other party had to basically compensate my client for this breach of reps and warranties. So it's really like looking at your contractual provisions to find a tool. And if you don't have that, or in addition to that, as Dino mentioned, then you have the options of going, instead of in addition, you may have the investment treaty option, which has been especially useful for in all the cases Paris mentioned against Spain, Italy, now Romania, where there were incentives issued by governments to attract investment in the renewable sectors. And after the projects were ongoing, the investment was made, the incentives were changed in a negative way for the investor. And this is a situation where you may not have a contract with a host state or a state-owned entity, but it basically severely affects your project. What do you do? So in these cases where if you have investment treaty coverage, you go to financial treatment, legitimate expectations, saying these incentives are invested based on these incentives, which created a legitimate expectations as to the profitability and the framework, and you've removed that, the state removed that, and should be held liable for it. And as was mentioned, I mean, the Philippines has a good investment treaty network. I think nearly 40, probably over 13 force, all the ASEAN investment agreements as well to cover like the regional investment and Australia, China. So even for foreign investors, but you may have Philippine investors who have channeled their investments in the Philippines. So they may also have an investment treaty option. It's more controversial, but through that back door. I think that there are ways to have remedies in case of change in law. Obviously, these days, the more you provide for it expressly in your contract at the outset, the easier to be down the line. So in a nutshell, but there are options usually.
Okay, well, thank you so much for that. And you actually mentioned 2 points, and I was hoping to unpack that. First, You mentioned something about enforcement, and second, you mentioned something about contractual provision. So maybe we can discuss the enforcement side first. Now, first, I'll ask Patricia and then Dino, and then the others as well. If you are to describe in one word, Patricia, the recent trend in the Philippines on the enforcement of arbitration agreements and arbitral awards, what is that and why? You may briefly refer to cases if you want to.
Okay. You're really making my life difficult. You know, lawyers don't like talking with just one word, right? But okay, so
exactly.
okay, I'll try to be deliberate. I think I would choose the word favorable. Enforcement in the Philippines, I mean, arbitration is not new. In the Philippines, way back in the 50s, it was already a concept that was discussed in Supreme Court cases. But it is only recently that there's been a push towards a pro-arbitration bias, not just in the executive or legislative departments, but even in the judiciary. So the Supreme Court has promulgated rules that are very pro-arbitration agreement, pro-enforcement of arbitral awards, regardless of where they are rendered. And just to give you an insight, the words public policy, the phrase, is one of the the most feared ways of getting an arbitral award not enforced, because it can cover anything. And if you look to the past cases of the Philippine Supreme Court, it could cover as something as inane as having a claim for attorney's fees as being against public policy. But recently, in I think 2018, the Supreme Court in the case of Mabuhay Holdings said, no, we're going to have a very restrictive and narrow definition of that term, and that not all violations of law will amount to public policy. So because of that restrictive approach, the Supreme Court is telling the people, the public, the users of arbitration in the Philippines, and all the investors out there that when confronted with an award, more likely than not, we will enforce it. So that is a good outcome at the moment. And I think that's favorable to arbitration. It's favorable to the profession, favorable to neutrals and advocates, and favorable to the users. Anecdotally, I'm a construction arbitrator, right? And this is how it has been so twisted. Anything construction related now, the courts refer to CIAC, even if there's no arbitration agreement. Oh, construction, okay, go to the CIAC and arbitrate. That's how far they've gone. So that just shows you how willing now that the courts are to enforce arbitration agreements and how to enforce awards as well.
Okay, thank you. Favorable. I love that word. Okay, Dino, next. Thank you.
For me, I would say the trend is pro-arbitration, at least at the level of the Supreme Court. I have recently surveyed jurisprudence in the past 5 years, and I'm pleased to observe that the Supreme Court has strongly taken a pro-arbitration stance. There are still instances at the lower court levels when arbitration agreements are not enforced or arbitral awards are vacated or modified. But when these cases reach the Supreme Court, almost always the Supreme Court would uphold and enforce the arbitration agreement and or the arbitral award in question. Let me briefly cite 2 examples from cases decided by the Supreme Court just last year. In one case, a party objected to arbitration and asserted that the case involved novel questions of law and a matter of public interest. The party, a government entity, was being compelled to arbitrate despite the pendency of a Commission on Audit investigation on the award and execution of the contract, including the arbitration clause. The Supreme Court upheld the referral of the parties to arbitration and said that arbitration agreements are liberally construed in favor of proceeding to arbitration. It cited the principle of competence and said that the arbitral tribunal has the first opportunity to rule on whether it has jurisdiction to decide the dispute submitted before its resolution. In another case, the Supreme Court was confronted with a situation where both the trial court and the Court of Appeal ruled in favor of vacating an arbitral award. The award was vacated on the ground of evident partiality of the arbitrator. On appeal, the Supreme Court reversed and said that it cannot agree with the lower court's findings that the arbitrator's act of disregarding certain documentary and testimonial evidence presented by a party by itself can rise to the level of evident partiality as to justify vacating an arbitral award. When it is the evidence upon which a party's claim is sustained or assailed that is questioned in the petition to vacate an arbitral award, the petition is a merits appeal, since it would entail the review of the findings of law and fact contained in the award. The court said that it is not allowed by the law and the prevailing rules on arbitration. So these are just some examples, but the Supreme Court for the past several years has been consistent in generally upholding arbitration agreements and arbitral awards, which is very encouraging for users of arbitration.
All right, thank you. So that's favorable and then pro-arbitration. And next, I also wanted to ask a similar question for Paris, now more broadly and globally, or at least within the region. Do you have one word when it comes to these trends?
Okay, regionally, I would say encouraging, because
Mhm.
you have all, from developed arbitral jurisdictions like Hong Kong and Singapore have traditionally had a very strong pro-arbitration approach. But what we tend to find is that even the developing countries that are just coming into the arbitration space or are actually, their courts are understanding that, yes, arbitration is completely different from litigation. It's not an appeal, and they are tending to adopt a more pro-arbitration approach, like Patricia and Dino have also highlighted. So I would say overall in the region, encouraging. We're getting there. We're getting to a point where courts understand their role, and it's to be non-interventionist and to give effect to awards, except for in the most egregious of cases. Yeah.
Mhm. All right, so we have favorable, pro-arbitration, encouraging, and then lastly, Elodie, hi.
No, you have to be the one negative. Like Singapore, Hong Kong, is like consistently pro-arbitration. There have been like major jurisdictions in the region which definitely are encouraging. I think like India, the recent decision, the Amazon case, agreeing to enforce an SIAC emergency arbitrator award. So that's definitely quite a major signal pro-arbitration. China, well, recently, a few weeks back, now as what's called one-stop, like the current system is that if you have an award, a foreign award to enforce in China, you may go to the intermediate court, so lower level court, and if the court doesn't want to enforce, then it has to refer it to the Chinese Supreme Court. But there is not much transparency about what's going on, that this process is happening and it may take time. So now the new one-stop process for awards issued in Hong Kong creates a one-stop within the Chinese Commercial International Court, CICC, where you can directly take the award issued in Hong Kong to the CICC to enforce it. And the CICC comprises judges from the Supreme Court. So it really streamlines the process, which is a good step. I mean, it's not available for all foreign awards yet, but it's a good step. After, I think there are still jurisdictions, especially at the lower jurisdiction where you have to go to a regional court first to try and enforce the award. I think situations definitely improving at the higher court level, but you may still have surprises in terms of basically reviewing awards on the merits, bias, or courts which are not that independent at the lower level. That definitely exists still in a number of jurisdictions in the region, and that can be an issue. I've experienced it when you get anti-arbitration injunctions, because this may be obtained by courts at the lower level, ex parte, or and basically then you have this injunction against the arbitration. In my experience, where I experienced it meritless. But even if you have an avenue of appeal, the injunction stays in place during the appeal, which can take time. So I think there are definitely countries where, I mean, and I experienced it wasn't in Asia, it was in a country in Africa. I would definitely caution about the seat of arbitration and having the seat of arbitration in the established, not up and coming or it's promising jurisdiction, but in an established jurisdiction, because if you get the award set aside at the seat, it will be very difficult to enforce it anywhere else apart from France. So definitely, I mean, but I think definitely the in terms of enforcement of foreign awards, the situation is improving in a number of jurisdictions in the region, which before were quite scary, and now there is like there is a reasonable chance it may be enforced, which is progress.
Yeah. Okay, then was that your one word, progress?
No, I think encouraging is encouraging, but
Yeah.
still with caution when it comes. It's a jurisdiction by jurisdiction basis. I think and encouraging probably still more in terms of enforcement than being comfortable putting a seat in the country.
All right. Thank you so much for that. And now, a while ago, I mentioned that one of the things that Elodie mentioned was about contracts. And with this, given the landscape, given the trends, how do you think these would impact how you would draft dispute resolution clauses? Now, for this question, I wanted to ask Dino first. Would you suggest a multi-tiered arbitration? For example, something that you would resort to good faith negotiations first, maybe mediation, arbitration, mediation, and other iterations of it.
Personally, the current landscape and trend do not really change the way I would draft dispute resolution clauses. There are benefits and disadvantages to having a multi-tiered dispute resolution clause. Whether the parties adopt one ultimately depends on the needs and preference of the parties. If the parties, however, are indifferent, I normally would recommend direct resort to arbitration. My view is that the parties can negotiate at any time if they really want to, but when there is already a dispute, I prefer having the option of immediately commencing arbitration and being able to seek interim measures from the court if necessary. Now, once the parties have decided on the structure and their preferred mode of dispute resolution, I normally suggest adopting the model clause on arbitral institution. I try to stay away from a highly bespoke dispute resolution clause, which in itself can be the source of additional disputes between the parties and potentially leaves open to question when and what disputes may or may not be submitted to arbitration.
All right. Thank you for that. And what about you, Paras?
Well, my answer is a typical lawyer's answer. It depends. Do we want a multi-tier dispute resolution? I think it depends on what you're seeking to achieve. You need to ask yourself questions such as, will negotiations or mediation help? Would they move things along? If so, how would they help? And, I think even before that, you need to ask yourself, if I'm drafting the clause, am I representing the claimant or the respondent or the likely claimant in a case? And if you are the respondent or the claimant, is it in your interest to drag things out, or is it in your interest to quickly resolve the matter? So my answer is it depends. I generally prefer clauses to be a bit more straightforward and to have less ambiguity. As Dino mentioned, the multi-tiered arbitration clauses can themselves be a source of additional disputes. If you think negotiations will help, should they be between? It's important to spell out very clearly. If you want to have such a clause in, it's important to spell out very clearly what the contours of the clause are, give a particular date by which negotiations would be deemed to have commenced or deemed to have ended, put the names of the parties or the designations in the parties who you think should negotiate. So should it be at the CEO level? And if that's not available, at what point do you say, look, we've tried, it's not working, let's go to arbitration? So again, it depends, but if you're going to put it in, make sure the clause is very clear and each party knows its rights.
All right, thank you. What about you, Patricia?
Okay. I will follow Paras and says it depends. It really is dependent on the transaction and the parties concerned. If we're talking about energy disputes or energy transactions, typically these are long-term relationships where investments are substantial, and you wouldn't want to waste all that and just suddenly go to a adversarial process. Because although arbitration is not as adversarial as court litigation, it still somehow is. So I would like to think that given the amount of investment or capital one has put in and the length of time you want to be together in a transaction, negotiations may help, especially if you look at the cultural aspect of it. Most Filipinos, and I dare say possibly Asians, would not want to take the first step to negotiation because it may be perceived as a sign of weakness. But if it's mandated in your dispute resolution clause that you have to go through this step, it may be less offensive or less of a sign of weakness for them to call on it and say, we will go through negotiation because it is required, not because we think our position is weak. So if you think your parties will have that kind of reluctance to negotiate, even if it's something that they can do because they want to save face or what have you, you might as well put it in. But I agree with Paras, it depends on who your client is and who will likely end up being in a dispute, who will be the likely claimant. And if it is not in your interest to prolong it, it is best to keep it a short period. You don't have to totally take out negotiation altogether. You can shorten the process and just subject it to parties extending the period as they want, mutually agreed. If this relates to a construction matter, I would put in, and this is because I am an accredited FIDIC adjudicator, I think the dispute board historically helps in a construction project. The dispute board process, especially a standing one, can be provided as someone who will resolve disputes as and when, give advice as and when, and that prevents matters from going to arbitration. At least that's the historical evidence. So if you have that in place in a complex construction project, it may prevent parties going to arbitration. It may make the project go smoother, finish quicker, or at least on time. So that's how I would approach it.
All right, thank you so much for that. And then Elodie, do you have any thoughts on multi-tiered, multi-tiered arbitration, or at least the clause?
Yes, I agree with what has been said. But in a long-term contract or in a joint venture contract where there is a concern about preserving a relationship, I think clients have increased appetite because of the cost and the length of arbitration for early resolution mechanism. I think mediation is gaining traction and has proven quite successful even in for large energy disputes. So I think, but you have to be clear about what you want when you draft the clause. If there's going to be, is it optional? Is it mandatory? Is there a time limit? And it's preferable to have one. A mediation can be quick. You don't need to have like a year. So I think it's definitely something to consider and which can be valuable to have an early resolution of the dispute. One concern, thing to bear in mind is what if you need interim measures? Because the mediation, even if it's quick, will take a few weeks or even months. So are you in a jurisdiction where you could go to court and have the interim measures you need pending the mediation if you need to? So that would be my concern. And when I've had reservation like or face dispute resolution clause multi-tiered, I think the concern is always how quickly can we get interim measures? How do we get interim measures?
All right, thank you. And then, well, at this point, I wanted to ask our viewers or the audience to start typing in your questions, where it's at some point very soon, we'll start reading all the questions from you. Okay, so Elodie, I also wanted to ask you, so we've talked about multi-tiered arbitration clauses. I wanted to ask about, would you suggest an exclusive resort to arbitration, and why?
I think if you're going to resort to arbitration, you have to be clear about what you want. It should be well, one thing, there shouldn't be any ambiguity about a given dispute, whether it goes to court or arbitration, because then you may end up to just an unworkable arbitration agreement. The splitting arbitration agreements where you say part of the dispute goes to court, part of the dispute goes to arbitration. I'm not a fan of that, because then you may have two forums, or you may have to rush to a forum, and then there would be like kind of a debate as to what falls under what part, and you may have parallel proceedings, and it seems very complicated. So I'm not saying never go to court, but make a choice clearly. If you want to submit the dispute to arbitration, make it mandatory and make it exclusive. The same, if you want to go to court, make it mandatory, make it exclusive. Basically, be clear in your choices so you don't end up with a one-year jurisdiction phase to debate what you meant.
Yeah. Okay. Thank you so much. How about you, Patricia?
Well, I agree with Elodie. I myself am not fond of splitting jurisdictions, not only because it can be exploited by people who don't want to proceed to an arbitration. They will say that it's not within the subject matter that's arbitrable under the agreement. But it can also, because if lack of clarity, it can become fodder for litigation. And there are more chances of mistake if you do try to separate. So unless you have so much time and it's really clear cut what goes where, it's best to just stick to one. And as Elodie said, if you want to go to arbitration, make it mandatory and make it go to arbitration, pick your institution. Or if you want to go to litigation, then provide for that expressly. I actually saw a couple of Philippine government agreements that provide for arbitration, but split the institution, which for me was quite complicated. It said, especially under the nuances of our laws, it says for non-construction disputes, you go to SIAC or ICC or what have you. For construction disputes, you go to the center that was mentioned by Dina earlier, SIAC. But it then goes to the definition of a construction dispute. And if you look at our laws, it covers everything. So it just complicates matters. So pick arbitration or litigation, make it mandatory, and pick only one institution. Provides for less problems than if you try to split everything up.
All right, thank you. And Paris, any thoughts on the subject matter?
I actually agree with Elodie and Patricia. Generally, it always helps for parties to have a clear idea of the forum in which their disputes will be fought, rather than different parties running to different fora in the event of a dispute and spending years in determining jurisdiction, which party came first. And again, I agree with Patricia when she says, pick between arbitration and litigation. In some situations and in some jurisdictions, litigation might be more advantageous. So it will really depend on where you foresee the other side has assets if you're the claimant. So it might be in your client's interest to provide for litigation rather than arbitration in some cases. If, of course, you are looking to enforce all the way around the world, then arbitration is probably your best bet. So, yeah.
All right, and then Dino?
I agree with everything that has been said so far. It is important that the arbitration agreement is clear. The last thing you would want is a dispute on whether a matter is subject to arbitration or court proceeding or some other submission to another agency or government entity. So for me, it's important that to try to keep the arbitration agreement simple. Again, if it's possible, I recommend adopting the model arbitration clause of an established arbitral institution. At the end, it's important so that, again, there would be no dispute as to what is subject to arbitration, and there would be less risk for multiple parallel proceedings, which really would not serve the interest of the parties. It would just entail a lot of legal costs for them.
All right.
Rob, sorry,
yes,
may I
please.
just interject? For the Filipinos in the audience, you may want to know that the Philippines is party to the New York Convention, which, as Paris mentioned, you can enforce your arbitral award in all the convention states. But the Philippines is not party to any convention that allows enforcement of foreign judgments in civil cases. So it will have to go through a prolonged process to enforce a civil judgment received in another country, because we're not party to that convention.
All right, that's a very important point, and thank you so much for that. Okay, so last matter with respect to drafting arbitration clauses, and this is one of those usual questions that lawyers and in-house lawyers would have. It's about the governing law. So I wanted to ask everyone, do you have any preferred governing law and seat of arbitration? And why is that? Why is it your preferred one or your suggested one? For this one, I wanted to ask Paras first.
Given that this conference is sponsored by the SIAC, no, I'm joking, of course. I would pick Singapore and SIAC as the seat in arbitral institutions usually. The reason is I mean, if it's a contract in Asia, usually you will have one party that's overseas, from overseas, probably usually not even from Asia, and one party from Asia. Both parties would usually want a neutral venue, and the SIAC and Singapore are notoriously pro-arbitration, and they are ranked in the top 5 arbitral institutions and seats of arbitration in the world. So SIAC would be the usually the arbitral institution of choice, with Singapore being the seat of choice, because that gives certainty to parties that their arbitration process will be quick, it will be efficient, and any award will likely be enforced.
All right, thank you. And how about you, Patricia?
Okay, I don't want to seem unpatriotic, but okay. Typically, if I'm asked, of course, I'll say Philippine law, because that's what I know, right? I'm not going to attempt to try and tell the client that it's good to have another governing law if I don't know it. But and the seat, I would say, to be patriotic, the Philippines. But if they do want a neutral seat, I would really suggest Singapore. And of course, I'd go institutional, therefore SIAC, not because they're sponsoring this webinar, but because history shows that they are efficient. They are efficient. The awards that are rendered out of SIAC proceedings are typically enforced. So it is a good forum. And it's always pro-arbitration, in the words of Paras, notoriously so. And the clients want that, should they end up in a dispute.
All right, thank you. Elodie?
Yes, I agree. Singapore. I mean, like the seat and the options are, I would say, you're looking at a seat where you trust the local courts, where you're not going to have undue interference, where you're not going to have the award set aside for meritless reasons. So the rule of thumb is that if you wouldn't want to go to court in that jurisdiction, then you don't put your seat there. And then kind of narrow down the list of the places you consider in Asia and elsewhere. So I think Singapore has like the track record of being pro-arbitration. So there is a predictability. You can trust the courts are not going to be interfering or derailing arbitration, definitely not. And you couple that with the SIAC, I mean, with also an arbitration institution with a track record. I think that's a very, maybe the safest and the best choice in the region, because there is an increasing uncertainty about Hong Kong, especially if you have a long-term contract. What will happen in Hong Kong 5 years, 10 years from now, who knows? In terms of governing law, I mean, I usually tell my clients, it's secondary, and because you can have the governing law of your choice, but if you don't have an effective dispute resolution mechanism to enforce it, it won't help you much. So in terms of trade-off, it's better to get a good seat where you will have an efficient way to enforce the contract, your rights under the applicable law, and trade-off. So it may be, for instance, to take a country, you have arbitration with a Vietnamese party, you're going to put seat in Singapore Vietnamese law, and that's fine. But I would give up the governing law to keep the seat a good seat.
All right, thank you. Dina?
Well, I'm most familiar with Philippine law. I have no specific preference for the governing law. It really depends on the intended contractual relationship by the parties. So I evaluate it on a case-to-case basis. For the seat of arbitration, like what others have said, I tend to favor a foreign neutral venue. My personal preference is Singapore because it has an established reputation for having an independent judiciary which maintains a pro-arbitration stance and is well-versed of complex arbitration-related legal issues. To the extent that the seat of arbitration will also be the venue of the hearing, Singapore is known for its world-class infrastructure and its facilities for hosting arbitrations.
If I may just
All right.
add something with the governing law, which
Oh,
I've
yes, please.
experienced a number of times in the region where you would have like English lawyers often drafting the contracts, and you would have very English terms, like I mentioned, reps and warranties. And yet you would have a civil law governing the contract, where these concepts are not known, or there is no particular like regime for these concepts. And sometimes this kind of mismatch between the terms of the contract and the governing law. Ultimately, it's manageable. You just treat it as the provisions of the regular contractual provisions with the rules on interpretation in the given country. But that's something I've seen a number of times in the region where you have a clearly English law drafted contract, but the law governing it is not English law, it's a civil law.
All right, thank you. So we have one question from the audience, an earlier question. It's about the CIAC, or the Construction Industry Arbitration Center. And this is something that I wanted to ask Patricia about. So I'm going to read the earlier question. The construction of renewable energy projects in the Philippines typically involves foreign suppliers for the equipment and materials. Naturally, access to a neutral forum is an issue that usually comes out during contract negotiations. Can we consider SIAC as a neutral forum, or are we required to use CIAC?
Okay, thank you, Rob, for that question. Like, it is not clear-cut. Unfortunately, our laws are not as clear vis-a-vis jurisprudence. There is a Supreme Court case where, as mentioned by Dino earlier, the High Court said that the CIAC, the Construction Industry Arbitration Commission, is a mandatory alternative, meaning it's not exclusive a jurisdiction. If the parties want to go to somewhere else, they can provide for it. But there is a separate school of thought that says EO 1008, which is the charter of the CIAC, and the ADR Act of 2004, Republic Act 19285, that says CIAC has exclusive jurisdiction over construction disputes in the Philippines, where the disputes are covered by contracts with arbitration agreements. So if you look at the wording of the laws vis-a-vis jurisdiction, it would appear to be exclusive. But the Supreme Court, faced with EO 1008, said it's only a mandatory alternative because arbitration is consensual. You cannot impose on the parties an institution they don't want to go to. So the Supreme Court, I think, was coming from that particular mindset that they cannot impose, but they can provide a mandatory alternative under the law. So if the question is SIAC, the Singapore International Arbitration Center, is it a neutral forum? It is neutral if none of the suppliers are actually from Singapore, right? A neutral forum has to be a third-party forum. But is it something available to parties entering into a construction project in the Philippines? My suggestion would be to avoid the dispute, just already provide for what the law requires. Because it's quite difficult to say that the Supreme Court has interpreted it this way when you have the latest law, which is the arbitration law, saying it is original and exclusive jurisdiction. So the CIAC would seem to have original and exclusive jurisdiction. under the later law, which came after the decision of the Supreme Court. So it is best to just follow the policy of the law and provide for SIAC. That will prevent enforcement problems later on. Because if you provide for SIAC, because it's a consensual thing, you go by the mandatory alternative and someone goes to SIAC, the Construction Industry Arbitration Commission, enforcement may become an issue, particularly for the Filipino, right, who may want to enforce against the foreign supplier some claim. And that what would happen is they can't enforce it because they went to the Philippine Commission instead of going to the agreed institution. So to avoid question and problems on enforcement, you better just agree on what is the policy currently, and that is the SIAC, Construction Industry Arbitration Commission.
All right, thank you. And then Dino, I was going to ask you too if you have any reaction to this and the others as well.
I agree with what Patricia said. If I may just add, of course, on the assumption that SIAC and SIAC would be alternative forums, as Patricia said, the word of the law is exclusive, so it's not concurrent jurisdiction. But on the assumption, based on jurisprudence, that the parties may go through the stipulated arbitral institution or go through the SIAC, I would just like to point out that the enforcement and the post-award proceedings would be different. So unlike SIAC arbitration, whose awards may not be appealed on the merits before the Philippine courts and may only be set aside or refuse recognition on the limited grounds provided by the UNCITRAL model law, the New York Convention, and the special ADR rules, SIAC awards are ultimately reviewable by the Supreme Court on pure questions of law and by the Court of Appeals on grounds that go into the integrity of the tribunal, such that the actions of the tribunal constitute grave abuse of discretion amounting to lack or excess of jurisdiction. Thus, to the extent that the parties would want a neutral forum, because you asked about the issue of neutrality, where there is less likelihood that the merits of the arbitral award will be reviewed by Philippine courts, I would say that an SIAC arbitration enjoys some advantage in this regard. Again, on the assumption that both forums are available to parties.
All right, thank you. And then Paras, do you have any comments or maybe even questions about this topic?
Sure. I mean, the CIAC is for construction disputes in the Philippines has mandatory jurisdictions, as Dino and Patricia have pointed out. And they've also pointed out the impact of that in the Philippines. But outside the Philippines, the fear, of course, is that if parties have chosen another arbitration forum or arbitration institution to handle their disputes, and the CIAC tribunal assumes jurisdiction under the mandatory provisions of Philippines law, there's a risk at the enforcement stage. So if the Filipino party wins and enforcement needs to take place outside of the Philippines, arguably the state in which enforcement is sought, if it is party to the New York Convention, can refuse enforcement under Article 5D of the Convention, because a court in such circumstances can refuse enforcement where the composition of the arbitral authority or the arbitral procedure was not in accordance with the agreement of the parties. And so imposing a mandatory arbitral institution and a method for arbitration when parties have agreed to something else might prove problematic at the enforcement stage. And what you might be left with is a paper judgment. And so there is that risk with imposing a mandatory jurisdiction of the CIAC.
All right, thank you. How about you, Aditi? Do you have any thoughts on the matter?
Yeah, I mean, I agree with that. As been said, it's a difficult situation because basically, if you're kind of caught in the middle of like having a risk of enforcement in the Philippines if you go for your chosen arbitral institution, but having a risk of enforcement elsewhere if you go for CIC instead of the chosen institution. So I think you have to think about where you need to enforce and be practical about it. And I think a tribunal seated outside of the Philippines would have discretion to retain jurisdiction if the party's choice, the arbitration agreement provided for SIAC, the tribunal can retain jurisdiction and is not bound by the mandatory law of a foreign country, the Philippines. But of course, if you think you will have to enforce your word in the Philippines, you may want to be cautious, but not going for the SIAC. So I think it's there is no easy answer. I think if you have a given dispute, it's about what risk is the least.
All right. Thank
Rob,
you.
just to
Yes, please.
just to round out that. Okay, we have this discussion among the accredited arbitrators of the SIAC, and the one point that has been continuously raised is that providing for SIAC or any other institution other than the Construction Industry Arbitration Commission and insisting on mandatory exclusive jurisdiction is actually bad only for the Filipino. It's not because the award in Singapore in an SIAC proceeding can be enforced here under the New York Convention. And if the parties agreed to SIAC in their contract and the governing law provides for Singapore law, then there's no way any Filipino respondent can escape it. But if a Filipino goes to SIAC when the contract provides for Singapore, they will be unable to enforce it in the foreigner. So even if the contract, the governing law says Philippine law, even if it says Singapore law. So it appears to be disadvantageous only to the local party. So the argument is that if you are representing the Filipino, you better make sure to protect them and foresee that. So that's where at least where I'm coming from.
All right, thank you. And I do have a follow-up question about the SIAC. Can you select ICC arbitration rules administered by the SIAC? So I'm gonna ask both Dino and Patricia if you can respond to this. Maybe Dino first. If you have any thoughts on
I
this.
want to defer to Patricia on this because she's
Okay.
an accredited arbitrator of the SIAC. Although I'm not so sure if the SIAC administers arbitration under a different set of rules. I know that in other institutions that is allowed, but personally, I'm not aware if the SIAC would administer, for example, as an SIAC arbitration, an arbitration under the rules of the SIAC. I would believe not, but again, I would defer to Patricia on that.
Okay.
Yes.
There's no prohibition, let's put it that way. But the SIAC accredited arbitrators will likely refuse to have to administer an arbitration process under a different set of rules. Primarily, part of it is because unlike SIAC, when you adopt SIA, it's really consensual. In the Construction Industry Arbitration Commission, it's just a government institution, and it's under the DTI. So the chances are that we will insist on using our rules, which are consistent with SIAC law, right, and the charter, which, as you mentioned earlier, Dino, is quite different from an SIAC process.
All right, thank you. We have a non-SIAC question. It's about the Energy Charter Treaty. So is it advisable for more nations to sign and ratify the Energy Charter Treaty or ECT? And does ECT help resolve energy disputes in a satisfactory manner? Maybe this one I can ask Elodie, if you can take on this one.
Yes. So the answer may depend on whether you answer from the investor perspective or the state perspective. I think there is, on the government side, there is now efforts to revise the ECT. It's kind of viewed that it's a treaty from an older generation, so it has provisions really favorable to investors compared to newer treaties, which are more detailed and have more provisions to preserve the state right to regulate. So I'm not sure there will be much appetite by states right now to sign this type of treaty, because again, it's the trend is to have like a more detailed treaties with sustainable development obligation for investors and right to regulate. Does it resolve disputes effectively? Yeah, I mean, a number of the cases against Spain have been under the ECT. It's not, I mean, the provisions on investment protection in it are quite similar to investment treaties. So it's not, it's as good as a first generation investment treaty. So in that sense, it's a treaty which has been very helpful to investors. Again, it's a layer of protection in addition to the bilateral treaties, or in Asia, you have the regional ASEAN treaties. Only Japan and Mongolia in Asia are party to the ECT. So it's more like, it has been more used. I mean, there have been cases against Mongolia, but otherwise many cases have been used by in Europe. So I think, yes, it's a good treaty from the investor perspective. It's a sectoral treaty, but in terms of provisions, it's equivalent to an investment treaty. So I think to the extent investors would fall or would want to fall under it by channeling their investments, that's useful. That's useful.
All right, thank you. And then maybe Paras, do you have any additional thoughts on the question?
Yeah, I agree with Elodie. I mean, the ECT is wider in scope than current treaties and offers additional protections to investors. And you see, that's why Spain has opened itself up to about 50 claims so far, with probably more coming. So from a nation's perspective, there is little incentive to sign up to the ECT. Even though it does represent best practices, there's a lot of signatories, both from Latin America, Asia, and Europe. But that being said, I think that the trend with Asian governments is to negotiate BITs, which are a bit more detailed, a bit more specific to the context in which each country operates, rather to sign up to a mega treaty like the ECT with very onerous obligations. Yes and no is the answer, unfortunately. Yeah.
All right, thank you. We do have one last question. We had a few questions on this topic. It's about joinder of additional parties. Now, considering the complexities of the commercial relationships involved in energy development projects, can a third party participate in the arbitration process by a similar process of joinder as in regular courts? So I guess this is, I think we're assuming here a particular arbitral institution or even SIAC, for example. So for this one, maybe I'll ask, well, I asked everyone, but I can ask Elodie first.
Yes, so the SIC has a provision on joinder of third parties, but either the prima facie, the third party has to be bound by the arbitration agreement, or all the participants, including the third party, have to agree to the joinder. And I think one thing to keep in mind, like when drafting arbitration agreement, drafting contracts, is to anticipate, because even though arbitral institutions, including SIAC, have rules, there is only so much you can do if your contracts do not provide for what is not compatible with a joinder or consolidation situation. Meaning, if you have a various contracts relating to the same transaction, the arbitration agreements need to be compatible, at least identical if possible, but compatible. And maybe you have a first contract signed and later contract signed, and you're kind of in the later contracts, if you envisage a need to have like an arbitration, well, joined under all these contracts, you need to think, it means you may be stuck accepting putting the clause which was in the earlier contract. But if your clauses are not compatible or identical or compatible, you won't be able to do anything about it later on unless all the parties agree, which is unlikely. So again, it's in complex transactions, it's something even better if you can add in the arbitration agreements language on joinder and consolidation, so that it's clear. Because otherwise, it's very helpful that the institution, including SIAC, now have express provisions on it and procedures. But a lot of it still depends on the drafting of the contract, so it's on the parties.
All right, thank you. Well, we only have 1 minute left, but I do want to ask maybe Paras, Dino, and Patricia, if you have anything else to add to what Elodie said when it comes to joinder of additional parties. Maybe we can start with Dino if you have any.
Well, just briefly, I would just like to say that joinder would be governed by the specific applicable rules. So the question pertains to arbitration vis-a-vis court proceedings. So I would say that this would be different because, as Elodie pointed out, for SIAC arbitration, there's a specific rule and the requirements are specified there as to how a party may be joined in a proceeding. For court proceedings in the Philippines, that would be governed by the rules of court. There would be permissive and compulsory joinder of parties. So that would be under Rule 3 of the rules of court. So yes, to answer the question, the requirements and the process would be different and it'd be dependent on the rules applicable to the proceeding.
All right, Paras?
No, I agree with Elodie and Dino. I think joinder is something that needs to be thought through very carefully at the drafting stage as well. Otherwise, you foresee a lot. You generally have multiple fronts, or you foresee a lot of issues down the line.
All right, and then finally, Patricia.
Well, I agree with what everyone said, Elodie, Dino, and Paras. And I think this is where the reminder to all transaction counsel: do not leave the drafting of your dispute resolution clause to the very end. You should, as Elodie said, anticipate what you need and craft your dispute resolution clause accordingly. So the trend or the practice of leaving it to the last minute should be avoided.
All right, thank you so much. Well, I had always hoped for more time, but unfortunately, it's already 5:16. So I will now cede the virtual floor to Jasmine. Thank you so much, everybody.
Thank you.
Great. Thank you to our panelists for the very engaging and insightful session. That concludes the SIAC webinar. We hope you enjoyed the session. Thank you once again for joining us today, and we look forward to seeing you at our future SIAC events. Have a lovely day and evening, everyone.
Thank you very much.
Thanks, everyone.
Thank you.
Thank you, everyone. Bye-bye.